Welcome to the Heidi Thorne Show. I'm your host, Heidi Thorne, and in this podcast I share my real-world self-publishing and small business experience with you. Before we get started, I just want to remind you to like, comment, share, follow, and subscribe. Now let's get on with today's show. I see a lot of confusion and questions on author forums about trademarks, copyrights, and titles. While I'm not a lawyer, and this does not constitute legal advice of any type, I will provide some definitions and discussion of these terms, particularly as they relate to authors and self-publishing. According to the U.S. Patent and Trademark Office, a trademark is, quote, a symbol, design, or a combination of these things that identifies your goods and services. It's how customers recognize you in the marketplace and distinguish you from your competitors. Trademarks are primarily for products. If such a mark is used for a service business, it is called a service mark. A trademark is not, repeat, not the title of your book, although it could be at some point in the future. This is where it becomes confusing for authors. Some book titles have been trademarked. A prime example is Harry Potter. Warner Brothers and J.K. Rowling hold multiple trademarks for Harry Potter brands. However, J.K. Rowling holds the original copyright for Harry Potter. Harry Potter is an extremely complex case of IP, or intellectual property rights and licensing. Your self-published book is probably not in that same category. Though that's not to say that at some point in the future, you might want trademark protection for your book or related IP, such as characters. Traditionally published authors or their agents should look to include protection for IP rights for the future. Every once in a while, I'll run across a story where an author was so anxious to get a book deal from a traditional publisher that they overlooked provisions for protection of these rights. Then the publisher went on to create merchandise or other offerings, and the author didn't get a dime. Realize that protecting these rights through trademark can be expensive. Guidance and legal help from an intellectual property attorney is always recommended for these issues in both the traditional and self-publishing arenas. Sometimes you'll see a news story about a brand that has applied for ridiculous trademark status of a word or phrase. Paris Hilton's "That's Hot," for instance. And yes, she was successful in that endeavor in a suit against Hallmark cards. Then there was the whole Candy Crush issue some years ago, with the game maker filing and later dropping an attempt to trademark the word candy for gaming. An author on social media was concerned that a word he used in the title of his book would be trademarked, and he'd be liable for trademark infringement either now or in the future. Given the nonsensical trademark issues that have come up over the years, like the examples I mentioned, I understand why he asked. He should be concerned if he's using an officially trademarked term in his title, such as Harry Potter, Star Wars, or anything Disney. There are also issues of senior use, meaning that the earliest use may prevail in any dispute. If you are using generic words or phrases, there's less concern. According to the U.S. Patent and Trademark Office website, which is a great resource, you don't have the rights to the word or phrase in general, only to how that word or phrase is used with your specific goods or services. However, you should do a search for any special words or word combinations that you think could cause an infringement claim. As a first step, the U.S. Patent and Trademark Office website is helpful with its Trademark Electronic Search System Database, or TESS, where you can look up currently registered or applied for trademarks. Then for specific questions or concerns, consult an attorney who specializes in intellectual property. Authors may also confuse trademark with copyright, two different things that protect two different things. Trademarks are for protecting product brands. Copyright protects tangible creative works, whether it's in physical or electronic format. The one thing that isn't protected under copyright law is book titles. That's why you'll see so many books and songs that are identical or nearly identical. But that doesn't mean you can or should use a trademarked or copyright word or phrase in your title. Again, using the Harry Potter or Star Wars examples, you shouldn't include those names in your title. It can suggest that these are officially licensed by the copyright and trademark holder when it is not. Common sense should rule here. Protecting your rights and protecting yourself from claims can be messy business. As I've recommended throughout this discussion, an intellectual property attorney can be your best resource in managing these issues. I hope you found that helpful and informative, and if you did, please rate, review, and subscribe to the Heidi Thorne Show on whatever podcast app you like to use. I'm on all the major ones, including Apple Podcasts and Spotify. If you like the YouTube video better, all you have to do is subscribe to my Heidi Thorne YouTube channel and turn on the notification bell so you get an alert when a new video is up. I would appreciate it if you would share either the audio or the video with your friends on social media. My self-published books are available on Amazon, Audible, and Apple Books. All you have to do is go to one of those sites, type in my name, Heidi Thorne, and a list of all of the available titles will come up. If you'd like to connect with me, my website is HeidiThorne.com. Thank you so much for listening and for your support. I look forward to talking with you again in the next episode, and in the meantime, have a great day.